a perpetrator of abuse can be, and I'll explain to you why this is important. The CPS system has jurisdiction over cases where the perpetrator, the person who allegedly commits the act, meets these definitions. In the Jerry Sandusky case, Jerry Sandusky did not meet the CPS definition of perpetrator, who at the time had to be a member of that child's household or someone in a caretaking role. Well, if you think about it, a sports coach doesn't live with them, not in a caretaker role. I'm not in a parental role or family role, nor was a babysitter, nor was a teacher, nor was someone who was officially in a caretaking role. So there were a lot of discussions about things, but in reality, looking at it, it was really questionable whether this whole group of statutes would have applied in that situation. They have amended them so now that they would. So a perpetrator can be a parent of any age. It includes a spouse, a paramour, or a former spouse or paramour. So we can now include Brad Pitt in the definition of the child's parent. A person 14 years old, of age or older, who's responsible for the child's welfare, including any person who has direct or regular contact with the child through any program, activity, or service sponsored by a school, for-profit or religious or other non-profit organizations such as camps, athletic programs, enrichment programs, or troops, clubs, or similar organizations. That's the Jerry Sandusky rule that went in there. So, but it's expanded to, so any activities that would include, and the 14-year-old, and then school employees and independent contractors as well. So that if you have a school and you have someone who comes into that school as a consultant in a role, in one of those roles, even though they may not be a school employee, but they are an employee of an agency the school contracts with, this would still apply. And a perpetrator living in the same home as a child must be 14 years old or older. So remember a few minutes ago when I mentioned GPS cases? So if you have a 13-year-old, 12-year-old in the home that allegedly abuses an infant, a young child, that's GPS because they don't meet the definition of perpetrator. So that's where the line gets drawn. Individuals 18 years old or older, not residing in the same household, and related to a child within third degree of blood, marriage, or adoption. So that if you have a relative of the child that isn't living, let's say grandparents don't live in the home, they can still be a perpetrator, even if they're not living there, if they meet this definition, relational definition. And if you ask me specifically who would be a third degree, I guess it's, I just remember the old thing, first cousin twice removed or whatever that was. I never understood it growing up. I don't understand it now. But I think that this is when you defer to child line, they make those decisions. They will know those technicalities. So that was a perpetrator who acts, who abuses. Now, a perpetrator of failure to act, in other words, failing to do something that they need to do to keep the child safe, can be a parent of any age, including the spouse, paramour, or former paramour of the child's parent. And new laws are raising the age from the age of 14 to 18. So they really made lots of changes as it relates to the person responsible for the child's welfare, people residing in the same home as the child. And the reason they did this is to ensure that siblings and other minors who could not be perpetrators of abuse by commission, in other words, hurting, acting, cannot be considered perpetrators for failing to act. So that they're not held responsible for the action of adults. So you can't expect, for example, a 15-year-old child to protect a sibling from the act of a parent. They're not responsible for the parent's action. So they wanted to clarify that there's a limit to, you can hold someone responsible for something they do, but you can't hold young people under the age of 18 responsible for the actions of adults.